Hi students, today we can discuss on about the types of companies. The types of companies or the classification of companies. Before starting the session, let me once more read out the judgment in case of Solomon versus Solomon and Solomon Company Limited. On the previous video, I have made some misspellings on pointing out or reading out that judgment. The judgment with regard Solomon and Solomon Company Limited, Solomon versus Solomon Company Limited. The judgment is the continuation of the trade creditor could not be maintained. As per law, company is a distinct person from its members. The company cannot be regarded as an agent or trustee for Solomon. Secured creditors is entitled to payment out of assets in priority to unsecured creditors. Henceforth, company's assets must be applied in payment of debentures. In payment of debentures as a secured creditor in priority. That is, debenture holders must be paid at first in priority to the unsecured creditors. Only after that, unsecured creditors shall be considered. Okay, this is the judgment. Now let's begin our today's session. Okay. Now we are discussing about the types of companies or the classification of companies. How the companies are classified? Companies are classified mainly classified under four heads: on the basis of incorporation, on the basis of liability, on the basis of control, and on other criteria. These are the bases on which a company is classified. And let's begin. How companies are classified on the basis of incorporation. Let's discuss that on. On the basis of incorporation, a company is classified as charter company, statutory company, and registered company. And on the basis of liability, a company is classified as company limited by shares, company limited by guarantee, unlimited company. And on the basis of control, how a company is classified? On the basis of control, a company is classified as government company, holding and subsidiary company, foreign company, associate company. Okay. And on the basis of other criteria, a company is classified as private company, public company, one-person company, OPC, small company, association, not-for-profit or Section 8 company, producer company, investment company, dormant company, public financial institution, PFI, and Nidhi company. Okay. These are the classifications or the four major classifications and various heads under those major classifications regard the types of companies or classification of companies. And in this video, we can discuss about the classification of companies on the basis of incorporation and classification of companies on the basis of liability. How a company is classified on the basis of incorporation? Yeah, on the basis of incorporation, a company is characterized as charter company, statutory company, and registered company. And on the basis of liability, a company is classified as company limited by shares, company limited by guarantee, and unlimited company. Let's begin our topic. Classification of companies on the basis of incorporation. The first one is charter companies. What is a charter company? A charter company is those company or charter companies are those company which are created by grant of charter. Who grant this charter? The king or queen. The charter is granted by the king or queen. Bank of England, East India Company, British Broadcasting Corporation, BBC are examples of this charter companies. Next, we can discuss about statutory companies. What is statutory company? Statutory companies are those companies which are formed by special act of parliament, and the provisions of Companies Act 2013 is not applicable to statutory companies. Its statutory companies are formed by statute or special act of parliament. That is special act of parliament. The companies which are formed by special act of parliament are statutory companies. Some examples of statutory companies, the specialties are point to be noted is the provisions of Companies Act 2013 is not applicable to statutory companies and they are formed by special act of parliament. Reserve Bank of India (RBI), Life Insurance Corporation of India (LIC), Unit Trust of India (UTI), Employee State Insurance Corporation, Oil and Natural Gas Corporation. These are some of the statutory companies. Okay, now let's move on to the next characteristics or classification of company on the basis of incorporation. That means the way which is formed or incorporated. The next classification is registered company. What is a registered company? A registered company is a company wherein the promoters have taken steps to incorporate that company, and for that the promoters have obtained certificate of incorporation for the company. A registered company is those organization that is formed and registered with the appropriate statutory authority of that country. A registered company is formed and registered with appropriate statutory authority of that country. A registered company is a company or corporation and they are functioning in accordance with the corporate and securities law of that country. What are some of the examples of this registered company? Tata Consultancy Service TCS, Infosys, Reliance Industries Limited, Wipro, etc. are examples of some registered companies. The registered companies functions with accordance with the corporate and securities law of that country in which the company is registered. Okay, now let's move on to the next head of classification. What's the next head of the classification of companies? Yeah, companies are classified on the basis of liability. How a company is classified on the basis of liability? On the basis of liability, a company is classified as company limited by shares, company limited by guarantee, and unlimited company. We have already discussed that. And classification of companies are as company limited by shares are defined in section 222 of Companies Act 2013. What's a company limited by shares? For a company limited by shares, the liability of the member is limited by the memorandum. And what's that liability? What's the liability of the member for a company limited by shares? The liability of the member is up to only the unpaid and paid value of shares held by them. Suppose a person or a shareholder is holding a share worth rupees 100 and on regard he paid rupees 80 on various calls and rupees 20 is yet to be paid by that shareholder, and that's the liability. And for a company limited by shares, the liability of the member is limited to that amount which is remaining unpaid. That is, for this equity shareholder, that is, the liability of the member is limited to this limited to 20 rupees, for he have already paid the rest of the amount. For a company limited by shares, the liability of a member is limited to the unpaid value of shares held by them, and such shareholders cannot demand more. And the existence or at the time of the winding up of the company, for a company limited by shares, it's only this unpaid amount of shares or the liability on this unpaid amount of shares that's only exists from the part of the shareholder. Okay, now let's discuss about company limited by guarantee. Section 221 of Companies Act 2013 describes about company limited by guarantee. What's the liability of the member of shareholder with regard to the shareholdings of with regard to the company limited by guarantee? The amount of guarantee the member is liable to the amount he is guaranteed. The member of the company is liable to the amount he is guaranteed for a company limited by guarantee. And when this guarantee is given by some members at the time of becoming member of the company, at the time of becoming member of the company itself, the member is giving some guarantee for a company limited by guarantee. And for a company limited by guarantee, that can be classified further into two heads: company limited by guarantee having share capital and company limited by guarantee not having share capital. It's not necessary that the company limited by guarantee or a company in which the member is guaranteed some amount on regard the company is having no share capital or the company must have share capital. There is not such necessity. A company limited by guarantee may have share capital or may not have share capital. That's a two classification of company limited by guarantee. And now we can discuss in detail about company limited by guarantee having share capital. In such a company, that means a company which is limited by guarantee and having share capital, what's the liability of the member? The liability of the member includes the amount guaranteed by him. For a company limited by guarantee, there must be some guaranteed amount, and in such case, the member is liable to the amount guaranteed by him. And for a company limited by guarantee having share capital, yes, of course, the amount unpaid on shares held. That's also the liability accounts to be the liability of the member. And when the call money or the amount unpaid on shares are called upon by the company, that can be called upon at any time. What's the specialty of this guaranteed amount? That guaranteed amount may be demanded by the company only during winding up. That's an important difference between the amount guaranteed by a member and amount unpaid on shares. Amount unpaid on shares may be called upon at any time by the company, but the guaranteed amount which the member guarantees with regard to the company, that is called upon only during the winding up procedure of the company. Okay. Now what's company limited by guarantee not having share capital? For there is no share capital, the liability of the member is only to the amount guaranteed by him, and the guaranteed amount may be demanded only during the winding up of the company. Okay. Now let's discuss about the unlimited company. That's another classification under the head classification of the companies on the basis of liability. Unlimited company. Section 292 defines about this unlimited company. What's an unlimited company? A company which is having no limit on the liability of its members. That is unlimited company. What's the specialty with regard to this unlimited company? The whole of the company's debt and to the whole of company's debt and liability, the member is liable in case of an unlimited company. That is, the limited liability personality or the limited liability characteristics of the company or such feature of the company is not applicable or cannot be enjoyed with regard with an unlimited company. Here, the liability of the member extends to whole of the company's debt and liabilities. That's not including the amount guaranteed or unpaid amount on any shares. The liability of the member accounts to be in the whole amount of the company's debt and liabilities. And the creditors, the creditors are the persons who are or to whom the company is liable to pay such obligations by way of debt or any liability. Such persons can claim against only the company and not personally to the members that the debtors or the person with whom the company is liable. They cannot make a claim directly against the members, but the claims can be made directly against the companies. But however, the liability of the member extends to the whole amount of company's debt and liabilities. And this unlimited company can be further classified as unlimited company having share capital and unlimited company not having share capital. Okay. The members or the number of members with the company is to be registered with share capital, amount of share capital, and articles of the company. The articles of the company contains the number of members with which the company is to be registered, and for a company having share capital. The articles of the company for a unlimited company having share capital or not having share capital, the articles of the company contains the number of members with which the company is to be registered. And for a company having share capital or for an unlimited company having share capital, the articles of the company also contains the amount of share capital. The amount of share capital. Okay. For a company which is registered, a company which is registered, okay, and a company which is registered, and a company may be registered as a limited company or unlimited company. And for a company which is registered as a limited company, they cannot be converted to unlimited company. That's a point to be noted. A company which is registered as a limited company, XYZ Limited, XYZ Public Limited, such a limited company cannot be converted to unlimited company. A registered company, a company which is registered as limited company cannot be converted into unlimited company. On the other case, an unlimited company, a company which is incorporated or registered as unlimited company, that can be converted to limited liability company. There is no problem in converting an unlimited company to a limited liability company, but limited company cannot be converted to unlimited company. What are the procedures which should be taken care on converting an unlimited company to a limited company? Certain alterations are made in articles and memorandum in accordance with the provisions of the Act at the time of conversion, and any debt, liabilities, applications or contracts before such conversion of unlimited company to limited company are not affected with regard to conversion. Let's regard the conversion of unlimited company to limited liability company. The provisions of the articles and memorandum should be altered with the provisions of the Companies Act at the time of conversion, and the debts, liabilities, applications or contracts before the conversion of unlimited company to limited company are not at all affecting the newly formed limited liability company. Any debts, liabilities, applications or contracts made by that previous unlimited company before conversion are not at all applicable to the limited liability company which is formed by way of conversion of that unlimited company. Thank you.